Supreme Court's landmark verdict. Homosexuality no longer a crime under Section 377.
This is the judgment which has not disappointed, and the eyes of the global community have been on India. The media from the Western countries, from United States to UK to any country you name it, was in complete attendance today in the Supreme Court.
India celebrates crushing of the law that made gay sex criminal. And on this historic day, India's biggest legal luminaries speak to Mirror Now.
It has been a turbulent ride with ups and downs, and finally after maybe 5 years, the hearing has concluded.
No LGBTQI person can be denied all these rights. They are entitled to all these rights. They haven't decided about marriage, but that issue will come up in the future.
One very positive thing about this judgment is it takes it forward. And it takes it forward by recognizing the need now for a legal ecosystem in which relationships like this can survive.
The top court of the land once again driving in a long overdue change, overturning its own 2013 judgment. But even as the top court leads from the front, the big question remains: how much longer for society to change its mindset? Let's debate.
Watching the Urban Debate on Mirror Now, Faye D'Souza, thank you for joining us. Like we said, the Supreme Court giving us a landmark judgment, and it was a beautiful judgment that ran into nearly 500 pages. Parts of it reinforced the fact that it is not abnormal to be gay. There's nothing unnatural about it. It also said that the majoritarian view cannot dictate constitutional morality, which means that just because almost everyone believes something doesn't make it right, doesn't make it something that should be forced down everybody else. It talked about how as individuals we have autonomy over our own bodies and nobody can tell us what to do. Some of those we are going to go over one by one, but right now joining me on the show, Anand Grover, senior advocate with the Supreme Court, also the person who held the torch through this entire battle from the very beginning, from the Nas Foundation case onwards. Mr. Grover, good evening, and thank you for joining us. If Mr. Grover can hear me, I want to start by congratulating you and your entire team, Mr. Grover, for this amazing battle and for taking so many people along. Obviously, this was a special moment for the entire team, hearing the verdict from the Supreme Court.
Hello?
Yes, Mr. Grover, can you hear me?
I've lost you.
Okay, we'll try and get Mr. Grover back. I'll just try again.
Yes, I can hear you now.
Yes, okay. So you've been at the forefront of this battle, Mr. Grover, you and your entire team. The judgment that we heard today, unanimous from the 5-judge bench of the Supreme Court. What was your first reaction when you heard it? Is this something you were expecting?
Well, I've been speaking about the fact that the Supreme Court has left little choice for itself to decide the way it has decided today. So I expected it, but at the end of the day, after 18 years of struggle, with ups and downs, as you can imagine, victory is very sweet. And it could not have been better after very, very arduous struggle with a lot of difficulties, people not having faith and that sort of thing. But we were able to take everybody along. At the end of it, we have actually got what we wanted. And it's a very important historic moment, a watershed moment for India, where a community which was persecuted by the British, we imbibed that ideology and the sentiment of the British against LGBTQI communities, and we carried it further, making them into unapprehended felons or criminals. And it took a very long time to change the people's mindset after we took up the case in 2001. But I must tell you, and I must congratulate the media for doing its bit, because when we took up the case, the media actually started backing us after a few years, and that made a lot of difference. And I must take this opportunity through the medium of your channel to thank all the media for great support, for allowing discussion on this vital issue, and not in the manner that it is done in a number of channels, but constructive discussion. And I've seen priests, Hindu priests, Christian priests, and Muslim priests changing their point of view over a period of time because of discussion. And I'm a believer in changing points of view of people through constructive discussion by reasoning. And I think that was the forte, and also the fact that we were persistent for a number of years, and we knew justice was on our side so that we could win. And that goal was set, and we today have achieved that victory for all the people in India. It's not only for the LGBTQI community, but for everybody. Because this means from tomorrow, people will no longer be criminals who are otherwise criminals. The police won't be able to act like that. People will be able to stand high and tall and be able to say what they want, to be what they want, to express themselves in love or otherwise the way they are. So that's a huge change, and others will have to adjust to them. So I think it's a watershed moment.
Yes.
People who did not get freedom on the stroke of 15th August 1947, they've got the second freedom today.
Well, Mr. Grover, your journey actually began in 1998 when you picked up that case of discrimination against HIV patients, which led you to the NAS Foundation. When you look back now on the 18 years that you've led this battle, the community that you have worked with, the meetings, the consultations, the people in this community, what is your message right now for all of them, for those watching across the country who know you by name for the work that you have done?
Well, the message from our team to all the communities, whether they're LGBTQI or other communities who are fighting for the people who are marginalized, is you should remember that justice is on your side. You have to be persistent and not give up. Use all constitutional measures to secure your rights, and the victory will be yours. This is my message from the experience, not only of this case, but also HIV, which we also fought for a very long time. So I am very confident that people who need to fight, they have to be very, very persevering, and they have to be committed to their cause, and they can do it.
Mr. Grover, last question. Obviously, this is just the beginning. We've got equal rights now, but there are, the possibility of marriage, the possibility of adoption, all of the other things going forward. What do you see as the next step?
Well, a lot of challenges will be thrown up in the immediate future. The first one is going to be equality. A lot of people will be demanding equality. And in the private sphere, like your channel or the Lawyers Collective, they are private entities, and there's nothing to address discrimination in those entities. Yes. So if a LGBTQI person or a person who's a woman who's discriminated by a private channel, you can't do anything about it. So the first thing that has to be addressed, and you need a law for that, is to address equality and discrimination in the private sector. We were able to do that by the HIV bill, which has now been an act but has not been brought into force. But there's a need to have a comprehensive law on equality. The second issue, which will be coming forth fairly quickly, is on sexual offences laws. Rape, sexual harassment, etc. are gender-specific laws. You need to actually make them gender neutral, because a trans woman cannot access those laws and those remedies because that person is not considered to be a woman. And finally, the issue of marriage, that'll come up, and there the court may step in to ensure that people have equal rights.
Yes, Mr. Anand Grover, I do understand that we've taken up more of your time than we had agreed to initially, but I just want to take this moment to congratulate you and your team again for for the amazing work that you have done, and to thank you for the work that you have done on behalf of the Indian citizen. Mr. Anand Grover has been the torchbearer really for this entire battle for the last nearly 20 years to get this, to bring this community the right. Remember the NAS Foundation judgment that was then overturned in 2013, which a lot of people found completely disheartening. Mr. Anand Grover did not give up, continued to fight, and here we are today with a fresh judgment, a beautiful judgment, a 500-page judgment that we've tried fairly hard to read in the last several hours and to read through most of it. But this is what we're going to do. And here's my message before we start. The conversation about whether we accept the judgment or oppose the judgment is moot. It doesn't make sense. You cannot oppose the judgment. It's the Supreme Court. The Supreme Court has had its say. Swallow it and move on. You no longer have an opinion. And if you do, it'll be good. If write to me, I will send you the 500-page judgment and you can sit and read it because it is remarkable and it will teach us so many things. So we're not having a conversation today about whether or not it's okay to be gay, because that our question has been answered. We're not having a conversation about whether or not this judgment should have come, because that is quite frankly a waste of time. What we are going to do is we're going to look into the actual judgment, the nuances of the judgment, the things that have been said by each of these brilliant, completely brilliant justices of the Supreme Court, and what they meant. And we'll bring out some of the details. People have had questions. So what does it mean if the law has been changed? What part of the law has been changed? What does this mean for consensual, non-consensual sex? These are the things we're going to be doing. And we have some brilliant minds to help us do that. We have, Harish Salve, who's going to join us right through the course of the conversation for a bit. But Jerry Johnson is a lawyer in Mumbai who's also been part of the fight, along with Harish Iyer, LGBTQ rights activist. Arundhati Karju's counsel for the IITian petitioners who went in and petitioned along with the others to remove 377. Mr. KTS Tulsi is a member of parliament with the Rajya Sabha, senior advocate of the Supreme Court. Vikas Singh, president of the Bar Council at the Supreme Court. I welcome all of you to this conversation. Also Vinay Tiwari, consulting editor of the Times Network. Thank you for joining me as well. We have to start by looking at some of the main things that were said in this in this judgment. And I'm going to start by looking at the first judgment that was read out by the Chief Justice of India. And he looked at the combination or a comparison of 375, which is the rape law in India, and 377, which is the one that we're considering, which is unnatural sex, and considered the differences here between consent and non-consensual sex. And it was basically said that if you combine POCSO, which is prevention of crime of a sexual nature against children, and the rape laws, you cover all rape. And so there's no need here for this particular law to exist. Correct?
Yes, and I think one other important thing is they drew out, two judges in fact wrote that they drew out the dichotomy that now exists or had existed before this judgment between 375 and 377. Their point was that once this 375 was amended in 2013, it defined penetrative sex and included oral and anal sex as well. So here you have a situation where one section of the IPC makes it legitimate to have oral and anal sex if it is with consent, but another section of it actually makes it illegal. And they said this is prima facie dichotomous. You cannot have two sections which actually contradict each other. And hence, this was one big ground on which they believed that 377 should also be struck down.
Right. Mr. Tulsi, the question of consensual and non-consensual sex in this particular judgment was largely looking at consensual sex between adults, because they said very clearly that if it's non-consensual sex, it goes into the purview of the rape law or the POCSO law. If it involves a child, then there are laws against that as well. So for as long as it, and this is what people need to understand, as long as it is two consenting adults, then it is no longer illegal. Mr. Tulsi, is that, according to you, the most important part of the judgment?
That's an extremely important part of the judgment. In fact, I would like to congratulate the Supreme Court. I'd like to congratulate the petitioners, the lawyers. It's a remarkable victory. And Supreme Court has given us a shining example to be proud of it. But I think the foundation of this judgment is in a statement that it's not a psychiatric disorder. Up till now, the law assumed that this is an aberration. And then they say that there is no scientific evidence that sexual orientation can be altered. You are born with a certain,
Yes.
certain prerequisites.
Orientation, yes.
A part of your personality, you can't change it. Then they say that attempt to change is going to lead to low self-esteem for these people, and it will amount to stigmatization. So therefore, you should not even attempt to change their orientation. If it is whatever the nature has given it, they have to live with it, and it's not in their control. Then they say that sexual orientation is innate, and he or she cannot control, have no control over it, and any attempt will be repressive and violation of their free expression. You see, and the Chief Justice, in fact, makes some very bold statements that 377 is irrational, indefensible, and manifestly arbitrary. And there are two more statements which are extremely important, and he says the societal morality cannot overturn the fundamental rights of people.
Yes.
And societal morality cannot trump the constitutional morality. So they have put the constitutional morality as above all, and no one else. No one can challenge that, no one can defy that, no one can substitute that. It is the individual right which has been protected.
Yes.
So I think this is going to be one of the most important judgments of a long time.
Yes, in fact, joining us right now on the channel live is Harish Salve. Harish Salve, eminent jurist. Mr. Salve, thank you for giving us your time. Good evening. It is a landmark judgment we've received from the Supreme Court, unanimous from the 5-judge bench. We were just talking about the idea of constitutional morality and equal rights, and the Supreme Court focusing specifically on human dignity. What about this judgment? Do you think is the watershed moment? The points that were raised by the Supreme Court. Okay, we seem to have lost that connection, but we will go back to him in a bit. The idea, and I want to bring back the idea of constitutional morality. And this was an interesting thing that the Supreme Court brought up. Basically, it said that just because a lot of people, or even most of the people, believe something, that doesn't make it true. And that doesn't mean we have to force it on everybody else. So here is perhaps something that can be applied to other cases as well. Here is something that will probably be quoted in many, many cases to come as well, Vinay.
Just to add to what Mr. Tulsi said, I think one particular specific quote from the judgment is even more important in the current environment that we are in, where there is a widespread belief that just because there is a majoritarian view about something, it makes it the right view constitutionally. And they have specifically used that term. They've said majoritarian view does not equate itself with constitutional morality. So even if a majority of the people believe in a particular thing, it doesn't make it constitutionally right necessarily. And 3 judges have said this in their judgment, not one.
Yes, Harish?
What really it speaks about, it spells out not just about LGBT rights. It automatically speaks about, it gives every minority some sort of hope in believing that, you know what, just because I'm few in numbers doesn't mean my voice would not be heard. Because this spells out that aspect also. So it's not, though it's about LGBT rights, it's not just about LGBT rights. It automatically expands the scope.
Right, Jerry, also, I mean, the fact that when we're talking about minorities, and one of the problems also, one of the things that were used in 2013 was that this is a minuscule minority. There are only 200 people who have ever been prosecuted in under 377. So it's really not something that, we need to take the trouble to overturn, which is specifically what the court has addressed this time, that the numbers don't matter.
Correct.
What matters is equality.
Correct. What matters is rights, your fundamental rights to be an equal citizen in this country. So actually the court's judgment today really indicates that in the world's largest democracy, the bulwark against majoritarianism has to be constitutional law or constitutional morality. And that's what the court upheld. So by saying that it's not a numbers game, you cannot vote away fundamental human rights based on a majoritarian vote. The court has come out in defense of the minority of even one person. I mean, all you need is just one person to be in the minority, and that law should be able to protect and defend him. And, the court really had to step in because it was the government's duty to have done this. And it was the government's dereliction of duty that led this whole case to go up to the courts. We elect representatives so that they protect our rights. I mean, that's the most basic, the most primary, the first function of a government is protect the rights of the citizens who elected you to represent them. And because they didn't do that, and this is a democratic government that did not choose to protect the rights of its citizens, we have the court to have to step in.
In fact, I want to ask this question of Mr. Vikas Singh, President of the Bar Council, who joins us right now. Mr. Singh, Justice Chandrachud has actually pointed this out, the ambivalence of the government of not taking a stand. The government in this particular case left it, and I quote, to the wisdom of the courts. And the judgment calls out the government for doing that, saying you should have taken a stand, and leaving it to to the wisdom of the court doesn't absolve you.
True.
So has the court here pointed out to the government that it has perhaps not done its job?
Well, this is not only true for this particular case, but if you look at the large number of statutes which are on our textbooks today, they really are, some of them, like for the Indian, for instance, Indian Penal Code is of 1860. So there are huge amendments which are required to be done, and it should be done on a regular basis, which has not been done by the government because the parliamentarians are not interested in legislation. They are more interested in walking out and doing dharnas. And that's where the real problem lies. But in today's euphoria, we must not forget that the real judgment had come in 2010 by Justice A.P. Shah, division bench of the Delhi High Court, which had really said all what has been said now today by these 5 honorable judges. And really what had happened in 2014 was that a division bench of the Supreme Court had set aside that judgment on a very, very erroneous premise by bringing morality into legality and having their own very distorted sense of morality. So, I mean, they went on, what is good or bad and what can be said good in society or bad in society, and in that process you put in your own mindset in deciding a particular case rather than looking at the majority or the mindset of people who may be having this kind of an orientation. So, the judgment that really what has this judgment done is, it is not that it has really said that gay is correct or gay is something which is the way forward, but as of today we have only taken a small step in decriminalizing gay sex. So decriminalizing is, it's one extreme end of the spectrum where you say there are countries now today which legitimize marriage between gays, which legitimize adoption amongst gays. We are way behind even where the others have gone. But at least globally, now we can stand with a high head and say that we are not one of those countries which are having that retrograde law of punishing people for having this kind of an orientation. You'll be surprised to know even today there are 72 countries which still punish people for gay sex. And it was actually 73, but with today's judgment, India comes out of that list, so we are now still 72. And most of these 72 are either Muslim countries or African countries. So the Western world, the whole of the Western world is way ahead of us as far as the progressive thinking is concerned. And this judgment is a huge step in that direction, and restoring what Justice A.P. Shah had said in the year 2010, that you can't criminalize somebody for his sexual preference, and whatever one does inside the bedroom or inside a closed space is not for the state to monitor or the state to decide that it is correct or not correct, or for the state to say that it is punishable by law. So I think government definitely has failed in not amending the law itself and leaving it to the Supreme Court to take this important step. Because ideally, if the government had itself amended the law and decriminalized this, then this question would not have arisen at all. Correct. But as I pointed out earlier, the government doesn't want to take these kind of bold decisions and rather wants to rely upon Supreme Court judgments to sort of take a stand.
But that is true. The government does, I mean, an inordinate amount of litigation winds up in court because the government is not doing its job. And we have Mr. Tulsi with us. He's Member of Parliament. Mr. Tulsi, it's not just this government, but even previous governments who refused to take a stand or at least flip-flopped on their stand on the issue, leaving the matter for the Supreme Court. Have governments, consecutive governments refused, not wanted to, do their job?
No, I think the previous government had taken a stand, positive stand, before the High Court, and that is recorded in the judgment of Justice Shah. But in this case, the government did not take up the issue, but in the Lok Sabha, a private member's bill was moved for decriminalizing gay sex and LGTB. That was moved by Shashi Tharoor. And then another bill was moved by Trichy Shiva of the DMK in the Rajya Sabha, which surprisingly is perhaps the second private member's bill which was voted, which was unanimously adopted by Rajya Sabha. It is adopted by Rajya Sabha, in which it's far more detailed, and all the rights which the FGTB are concerned with, everything is dealt with in great detail. It's an excellent statute that was made, but after it is passed by Rajya Sabha, no further action was taken on that till now. But nevertheless, I think the legislators have been fairly active on this front. And I would like to mention a few of the subtle points that are made in the judgment by Justice Chandrachud. Justice Chandrachud expresses, he says that 377 is a tragedy and an anguish inflicted on people. And he says that this needs to be remedied. This is Macaulay's legacy, which has lasted us for 158 years. He says that there is human instinct to love and it cannot be constrained. He says sexual orientation has become a reason for blackmail. These people are getting blackmailed because of the harassment that they face from the police. LGBT also has a quest for fulfillment like any other human beings, and therefore you must ensure the state cannot decide what is permissible and what is against the order of nature. This is not for the state. That how you can indulge in sex and how you can't, it's a private act, and so long as it is consensual, no one can have a problem with that.
Yes.
And then he says that 377 is deep-rooted gender stereotype. It persecutes people. Its majoritarian impulse is to subjugate sexual minority. And then he says decriminalization is only the first step. I think the honorable judges have given these people, these harassed people, their constitution. It has given them some dignity, hope for dignity.
Yes.
It has promised them equality, and it has guaranteed them the fundamental rights.
Yes, in fact, one of the statements in the judgment was discrimination of any kind strikes at the very core of a democratic society. So they were very careful and mindful of the discrimination, of the fear, of the harassment at the hands of police, of the harassment at the hands of anyone else. And it was very clear about the fact that this judgment, giving equality, is the first step. We will have to make sure, the government will have to make sure that discrimination doesn't take place, and we're able to ensure evil society.
I just wanted to add one thing to what Mr. Tulsi said. Look, irrespective of what the previous government said in the court or not, whether the affidavit said X or Y, for me the salutary example of central government's behavior was what happened in the case of Professor Ramchandra Siras in the Aligarh Muslim University. Dr. Siras was a Marathi professor who was teaching Marathi in Aligarh Muslim University. When it was established that he was gay, his official accommodation was removed and he was thrown out of the campus. Ultimately, that man ended up committing suicide. This is a central university. This decision was taken by the government authorities to remove him from his official accommodation simply because he was found to be gay.
And also, I just want to point out, while Mr. Tulsi would say that, this was our submission to the court in the affidavit, in Parliament it is your job. You don't need the court to step in. You don't have to submit to the you can do this in Parliament as your job. But one second, before I come back to that, I understand that Harish Salve is back with us again. Mr. Salve, if you can hear me, good evening and thank you for joining us here on Mirror Now. We were discussing the nuances of the judgment, the 500-page judgment that came out today. If you've had a chance to go through it, what do you believe are the most important takeaways from a legal point of view in the fact that this has been read down and not removed completely, not struck down?
For me, the most important thing is the follow-up on the earlier privacy judgment. The privacy judgment established the right to a private space. It established that each one of us has a right not to be invaded, a right to our life without others stepping into it. As long as we don't hurt anybody and we don't do anything which is disruptive of society. The principle of private space has been taken to the next logical level, and I think where the challenge really lies is in our minds. We have become a society where we are happy to constitute ourselves into groups which feel that we know what is good for society and it's our view which must prevail over the view of any other person. We are becoming an intolerant society. And that's the reason, I mean, you hear instances of people being sacked from jobs, you hear people being ostracized. This will continue until our mindset changes. And the larger issue, therefore, with this judgment raises is, as the Chief Justice said, I am what I am and accept me for what I am, which basically means tolerance, which means acceptance, which means living with diversity. The second very important thing which this judgment gives you is the recognition that people who are in relationships which are beyond the ecosystem of the existing law also deserve to have their relationships recognized. Civil partnerships is a case in point. The English court started by recognizing civil partnerships. And civil partnerships are not merely between members of the gay or the LGBT group. Civil partnerships can be between a man and a woman who are living together. What in England, Lord Denning had called the common law wife.
Mr. Salve.
Now, we need to move beyond a statutory protection of the institution of marriage and extend it to all kinds of civil partnership uninhibited by people's personal choices. And that's the other important thing this court the judgment has said. And I think
if we look forward,
Parliament,
Mr.
of course,
Salve,
will take its own time to legislate because this, I'm sure, will continue to bedevil Parliament for a while as a controversial issue.
Yes.
But I'm sure if the court is moved, they will start applying common law principles at least to achieve some degree of architecture in the rights of these people.
Yes. So the things that now lay before us, the possibility of marriage between same-sex couples. Now, we have very strict personal laws, whether that is the Hindu, the Muslim personal law, the Special Marriage Act, the Christian, personal law. Would there, in your mind, need to be a separate law for same-sex marriages, or would they, based on religion, fall into their own laws? Because all of these religions agree on one thing, is that they don't like same-sex marriages. So how would this fit in legally? How would it work?
Well, I'm only reacting. You asked me this question, so I'm reacting on first principles, and I've not researched this carefully, but one good opening could be that if the court says, if you have stepped outside and entered into a civil partnership, you're in a class by yourself, then the conventional rules and laws will not apply. For example, if you're married under the Special Marriage Act, your customary law gets displaced to an extent. So if you enter into a civil partnership, which is a common law relationship, if that's how the courts recognize it, then they can equally carve out an exception for civil partnerships. The court has enough elbow room to create an architecture of civil law for civil partnerships. Once the court has recognized that something which is at stake here is a fundamental constitutional value, your right to privacy, your right to your private space, your right to live a life which gives you a sense of happiness and satisfaction.
All right. Mr. Salve, many thanks for joining us here on Mirror Now. It is a pleasure to speak with you, especially on an evening like this when we've had such a wonderful judgment coming out of our Supreme Court. We also have Arundhati Katju with us, the counsel for the IITians who appealed as well to the Supreme Court, and a very interesting argument they made. Arundhati, first of all, congratulations to you and your team, and especially the IITians you were fighting for. The argument that suppression of this kind keeps people from doing their jobs, it keeps people from earning a living, from thriving and being successful. Again, something that the Supreme Court has taken cognizance of. Livelihood, being able to live your life fully and be as successful and as ambitious as you want to. Was that specifically something that your clients found solace in?
You know, of course, this judgment is very meaningful to the IIT petitioners and I think to LGBT Indians all over the country. I also represented Navtej Johar and the first 5 petitioners who moved the court, as well as Keshav Suri. And what struck us was that across the board, you know, Navtej and Sunil and Aman are in their late 50s or in their 60s now. And the IIT petitioners were very young, but we were struck with stories of how the decisions that they're making were being changed by this law, and how, in some senses, we have to appreciate what India has lost because of Section 377 remaining on the books for so long.
Yes, what India has lost, and maybe that's something we should spend some time on, because that is also the way forward. And you were nodding, but what India has lost in terms of GDP was one of the arguments put forward as well.
Yeah, GDP is of course a big one that was part of Keshav Suri's petition. But what Arundhati is making a point is very important. The youngest petitioners from age 18 to 19, all the way up to the oldest petitioners, 60-year-old, all of them were impacted in one time by this one law. And so imagine the psychological impact, the productivity impact, the relationships that were not recognized, and therefore the relationships that broke up, families that separated. A lot of these IIT students are going to become the next, bureaucrats and IAS officers, the administration of this country. How many of those generations have we lost? How many of them have fled the country? How many of these brilliant, talented people we've lost?
You know, Harish, when we were looking at the celebrations in Chennai, the people in Chennai were lighting candles for the lives that were lost along the way. The suicide rate is extremely high in the LGBTQ community. One hopes that will change now.
That would change. That would need a lot of dialogue. But the fact that you understand that you have got no legal recourse, where you go, you recognize that you're gay, and you come out to your family, and your family will not accept you also, not because of anything else, but they don't want a difficult life for you. So they'd rather say that, oh, why don't you get married to a girl or get married to a boy if it's a girl, and live a life like everyone else. That became the normal. Pretend to be this thing. So what really happens is, rather than getting forced, sometimes these family compulsions also come because of Section 377.
There was one part of, and this is what I loved about it, that said, there is nothing unnatural about being gay. It was in the judgment. So for all of those people who offered to treat the gay people and fix them, this was possibly a reaction to that.
I think there's also a lot of yoga that's prescribed. Yes. I would prescribe yoga for a healthy sexual relationship, more flexible.
But not to go. All right. Vinay, the thing that we must address before we run out of time is read down versus struck down. Now, 377 in its form, as it was earlier this morning before it was changed, basically said that any sex that you have, without mentioning consensual or otherwise, that is against the order of nature, is illegal. And the judgment points out where this came from, and it dates back to the 1500s. It's purely, a Christian and Jewish and Western. It's not ours at all. And Victorian. We inherited it from the British, and we sort of hung on to it. But if we just focus on the reading down bit, where it hasn't been removed completely, there's something very important there that we should not lose sight of.
Yes, and if the court would have struck it down, it would have meant that the Section 377 would have disappeared from the IPC. So it hasn't disappeared at all. What it does is, it has retained the criminality of bestiality, which is having sex with an animal, and it has also retained coercion or force, which means sodomy still remains a crime. It only protects and actually protects voluntary sex between consenting adults.
And the Easter egg there is that it leaves, what it does basically is criminalizes the rape of a man.
Absolutely.
Which
And
doesn't
even
come
transgenders.
and
transgenders, which was very rampant actually.
Yes.
Which is a far bigger problem in many ways.
So if it had been removed entirely, then they would
that recourse would not be there.
recourse would not be there.
Because all the laws, I mean, if you look at the rape, anti-rape law and everything, it speaks about outraging the modesty of a woman. So it simply means that either men have no modesty, or it simply means that men have no place, no legal recourse at all. So over here, if there's any kind of force that is applied, you can.
And you know, this is important because between the gay community and the transgender community, we know that there was a lot of non-consensual, abusive, behavior and rape, and you didn't have the ability to go to the cops because all of it was illegal. So just existing was illegal. So now you have the ability to go to the cops, and you have a law to protect you. So it's really twice as good as we thought it was.
I think one of the most historic of the many historic judgments that we speak about, one of the very historic judgment is the POCSO judgment as well.
Yes.
Because as somebody who is a rape survivor himself, at that time, when I was trying for legal recourse first, as a male child, I had no legal recourse. Secondly, I was told that you have section 377 and it doesn't really matter whether you are
consented or not.
You're an adult or a child, it doesn't really matter because you're not a woman. You could possibly be seen as somebody who is a party to this. So I think POCSO was one defining with privacy as well.
There is one other thing, Faye, which is very important, which most of the people out there perhaps do not understand at all. 3 of the judgments today out of the 4 that were written have actually mentioned it and clarified this. For all those people out there who actually believe that this case was about one small section of people, actually the definition of 377 covered even heterosexuals.
Of course. Yes.
So technically by law, if you really went to the extent of strictly implementing it, heterosexuals were as much liable to be accused of crime as anyone who was not heterosexual. And by that logic, it frees up everybody. It just doesn't free up 7-8%.
So basically what 377 said, when you talk about the order of nature, and remember we're a country that wrote the Kama Sutra, but the order of nature by the Victorian concept would be simply a man and a woman, penal vaginal sex, the missionary position for procreation only, nothing else. So there's so much that, and that becomes illegal. And for all the people, like Vinay said, who are watching at home thinking this is about somebody else. It's not about somebody else.
The great irony was that you had the ardent of nationalists defending this British Victorian law with all of their energy as if it is their own. And as you said, we are the land of the Kama Sutra. We are the land of the temples of the Khajuraho. And for some reason, all of that went out the window and all of them were defending this British Victorian law. And just connected to the earlier points we were talking about, the judgment also says, and this is brilliant what Justice Nariman says, the Union of India is now responsible to spread the news of this judgment and the implications of this judgment far and wide. It has put the ball in the Government of India's court to say, ensure that our cops know what the law is, ensure that the cops know that the 377 remains on their books for people who need it, for acts of force, for transgender rape, but at the same time know that it has been read down so that consenting individual adults of any sex cannot be harassed under this law. So it's an important thing that now the government has to take forward.
Yes.
I've not heard anything from the government all day. Incidentally,
that's interesting. That's something we must take cognizance of.
Completely, Mom.
It's normally a press conference happy government, but we haven't heard a peep.
Not a peep from
anyone, except the RSS.
I think also Subramaniam Swamy has been continuously.
But technically, his member of parliament doesn't speak. I mean, they remind us on a regular basis that he doesn't speak for the government.
No, the past precedence is that any constitutional bench judgment that have come, the governments have reacted to it. I mean, in the past several years, couple of years, we've seen that happening. Today is an exception.
Yes.
Today they haven't come out at all. Not one person has actually spoken about it. So, I mean,
given the fact that it's a 5-judge bench and
a
unanimous judgment and 500 pages of clearly talking about equality, talking about mental health, and I just want to point this out. In the Justice Nariman portion of the judgment, he says, keeping in mind Article 14, 15, 19 and 21. So we're talking about all the fundamental rights.
In fact, Justice Indu Malhotra even added Article 19(1)(a) as well.
Yes.
Yeah.
So she drew references of freedom of expression as well. For her, this was also a violation of freedom of expression. So she added another angle to that, and that I think was very, very significant.
Which is why it's so important. Arundhati ji, the fact that this question was, and we just we had Anand Grover say it as well. For those people who didn't get freedom back in 1947 with the rest of us, they got freedom today because every single fundamental right had to be restored today by the Supreme Court.
Yeah, it's a big day because the court has also said that the Constitution applies in full force to LGBT people, and they've specifically mentioned Articles 14, 15, 16. So those are the equality provisions, and Article 21, the right to life. I believe one of the judges also mentioned specifically the right to intimacy. So it's really extended the Constitution's promise to LGBT people.
It really has. Vinay, are you surprised that the central government hasn't said anything so far? Although they've been given the homework, the Supreme Court has said you have to publicize this, you have to perhaps also draw up regulation on discrimination, because that's what it sounded like they wanted the government to.
There's also a suggestion that perhaps you have to apologize.
Yes.
There is also the suggestion.
It was not a suggestion.
To quote Indu Malhotra, she says history needs to apologize, but we know
who did.
Yeah, we all know who
So
that
to
will
answer
be.
your question, it's not just that I am surprised. Justice Chandrachud was equally surprised, and he ended up writing it in his judgment. And I think that line needs to be quoted because it's a very fascinating line. He says, "We would have appreciated if the government had come out with a categorical statement of position, which it chose not to do. However, ambivalence on the part of the government will never and should not obviate the need for judgment and justice." Now, irrespective of the silence, the fact of the matter is this ambivalence is obviously coming from a position that they have taken in the past. I mean, I don't think the government would have bargained for 5 judges coming out with a unanimous verdict, which is so scathing in nature. I mean, they've almost torn the 2013 judgment to shreds.
Yes.
Justice Kaushal judgment has been hammered in every single judgment.
It was a prime target for all of
Every
5
judge
judges.
has mentioned that and how bad it was in law. So clearly, this was very, very strong, and I don't think it's possible once you take a position on this kind of an issue, which is moralistic in nature, to then come out and say one way or the other.
And I mean, even on this show, Faye, many a times we have had people from the ruling party, you have a China NC coming and say that, oh, there will be a time when we can start discussing on these issues. The society will take time to grow up. Now, where are these people?
Yes.
I mean, where have they disappeared? I mean, now the society has woken up, the judiciary has woken up, the constitution of our nation has woken up. But I think we need to wake up these people.
I think what we find the government on a regular basis doing with uncomfortable questions. Marital rape, for example, was also a similar. We're not ready. We're not ready to give a woman the right to say no. So similarly, backing, saying, oh, we have to wait for society to be ready for the law instead of moving it the other way around.
We were discussing it earlier in the day, Faye, that in the government's affidavit, even though they said that we leave it to the wisdom of the court, they have put in that caveat that this is only specific to
Not
this.
for
If there is a
marriages.
further follow-out
of
the
marriage and adoption,
then
we
we
will
have
have
a
an
role.
opinion
Then
about
we have
it.
an opinion
Yes,
on
we will
that,
have
and
an
we wouldn't
opinion
want to be in
about
that.
The thing that I do, want to quote here is the reminder that was put into this judgment that the Constitution is a living, breathing, organic document, very much alive to its surroundings. It will constantly move. So while we have a government that may want society to sort of organically become ready for a law, I think the Constitution, the Supreme Court has pointed out, and it's done this in the past as well, that the Constitution is not locked in stone just because it was written 70 odd years ago, nearly 70 years ago, I beg your pardon. It's not locked in stone. It has to constantly evolve with society. So Jay, this is the important thing. The fact that they've reminded us that it's the first step. So the door is open as far as the Supreme Court is concerned for all of the other things we want to discuss.
Oh, indeed, very much. I think the Supreme Court is definitely making a statement that
Actually,
the purpose of the law is to expand the compassionate purpose of what a civilization is supposed to achieve. That's what the law is supposed to do. So that's exactly what the judgment is also saying. The judgment is saying that let's expand the possibility of rights and possibilities of freedoms, and now let's start taking advantage of it. And one of the things that I think with lawyers like Arundhati and others, what we have to now do is we have to now push for complete civic rights, basically equal civic rights that every other individual citizen of India enjoys. We have to now start pushing for that, because that's where that's the going forward.
I see you smiling. Go ahead. Do you have a plan already?
No, I have no plan. Today is a day to celebrate. It's to celebrate the petitioners, it's to celebrate the court, and it's to celebrate our constitution. But one of the phrases that the courts use, Faye, is transformative constitutionalism. And it recognizes both that the constitution changes and our understanding of what the constitution guarantees changes with changes in times, but also that the constitution has the potential to change. So the constitution itself is an agent of bringing about social change. And I think the court has stood for that today and really stood for it wonderfully. So, there are battles to be fought in the future, but today is really a day to soak it in and to celebrate, because it's been a very long journey for LGBT people.
Very, very well said. I just want to point out, do you realize that babies born tomorrow will be born in a country where being gay is not illegal, and perhaps will grow up in a country where it's not weird and it's not, it's not something to be hidden.
Since you mentioned, I think we should let people know, because it's important to know that one of the judgments even specifies that all the pending cases need to now be heard keeping this judgment in mind.
Dr. Justice Indu Malhotra said that this will now have an impact.
The prosecution is already finished, they won't be reopened. But the ones which are pending, now that's a big thing, because normally laws are not retrospective in effect in the sense, I mean, even from the time of the offence. So it's a big thing for them to have said so in the judgment.
Absolutely. Now, we have run out of time, and I want to thank all of you. And yes.
I actually want to thank Arundhati as well. I mean, thank you for this wonderful, fantastic job that you've done for all of us.
Thank you, Arundhati.
Oh.
Well, on behalf of all of the citizens.
Thank you all. And I think really thanks goes to the petitioners for standing up.
On behalf of all of the citizens who are watching and the Mirror Now team, Arundhati ji, I thank you and your team for the wonderful work that you have done. Obviously, like you said, this is just step one, and there is a longer battle ahead of us. But it is a night to celebrate. It is a night to celebrate some very important things. That we are today a country that is truly equal. We are today a country where fundamental rights belong to each and every one of us, irrespective of our choices. That tomorrow morning, we will wake up in a country that does not discriminate. Our Supreme Court has made it very, very clear that it does not discriminate, and we are not allowed to discriminate. And when you discriminate against someone, it is as good as killing that person. Forcing somebody to hide who they are and not express themselves is as good as killing that person. So what we need to remember is this: there are a lot of things that happen in our country that might be disheartening, that might make you feel sad at the end of a news day, that things like this happen. Today is a day to feel happy, because irrespective of what the reality is, we know we can always knock on the doors of our Supreme Court, and our Supreme Court has delivered time after time, judgments that have restored our faith, judgments that have restored our rights, and judgments that have stood by the citizen. We leave this evening with a simple message. Thank you to the Supreme Court. Thanks for watching.